You're watching Education for Health Professional Regulators of Ontario, colleges under the Regulated Health Professions Act. Richard Steinica is a senior partner of Steinica Mikura LeBlanc, and he practices exclusively in the area of professional regulation. Richard is a noted author of the Complete Guide to the Regulated Health Professions Act, which, because of its comprehensive nature, has been cited by courts and tribunals, even in cases dealing with non-health professions. Marshall Molesky is the past president of the Federation of Health Regulatory Colleges of Ontario, and he serves as Chief Executive Officer and Registrar of the Ontario College of Pharmacists. Join Marshall and Richard now as Marshall poses a number of important questions on behalf of those of us who want to know more about regulating healthcare practitioners in Ontario.
Richard, you've used the word equity a lot. What do you mean by equity?
I mean substantive fairness. People need to be treated equally, and sometimes that means, in some circumstances, you have to make extra effort to ensure that there is true equality. So, for example, scheduling a meeting on a day that a committee or council member uses as a religious day of observance would not be treating everyone equally. This obligation applies to everyone the college deals with: practitioners, applicants, the public, staff, and other council and committee members.
Is the Office of the Fairness Commissioner an example of an equity initiative?
Very much so. This was initiated in order to ensure that international applicants are fully recognized for all of the competencies, knowledge, skill, and judgment that they have. The impact, however, has been that all applicants have benefited from a transparent, objective, impartial, and fair process, and from the Fairness Commissioner monitoring that the colleges are doing this. A similar initiative has been the Agreement on Internal Trade. This is a results document that says, because a practitioner practices in another jurisdiction in Canada, we have to assume that they are as qualified as anyone who practices in Ontario in terms of their education, training, experience, assessment, and currency. And so you can only look at the non-qualification requirements for registration for someone who's registered in another province. For example, have they filled out the application form? Have they paid the fees? Are they of good character? Do they have professional liability insurance?
How bilingual does the college need to be in the official languages?
This is a duty of the college to ensure that people can use French in all dealings with the college, including communications, exams, registration, hearings. And the college even has to identify and record the English or French preference for practitioners. There are limits where it's not reasonably possible in the circumstances for the college to do so, but that is the duty, and it is a duty that the legislation imposes on the council, not on the college, but the council, to ensure that this is done.
When one thinks of equity, one automatically considers human rights. To what extent does the Human Rights Code apply to the college?
There are two provisions in the Human Rights Code that apply directly to the college, saying that you must treat all people equitably in respect of the protected grounds. And those provisions override anything that's inconsistent with the legislation that applies to the college. So there's various types of discrimination. There could be, for example, a direct discrimination, which would be extremely rare in the college context. There could be insensitive or stereotypical thinking, where perhaps we think a certain thing about an individual, and we need to get beyond that and be sensitive about that. We also want to be sure that we're not treating people differently. For example, we're not imposing additional requirements on international graduates that don't need to be there. Sometimes treating people the same can be discriminatory. For example, requiring someone to produce a document that because of their place of origin, they just are not able to provide. Finally, there is the possibility of systemic discrimination. This is very rare, but there has been an instance where a regulatory college was found to have engaged in systemic discrimination against a minority group. The Human Rights Code requires that there be accommodation of someone if they have a disability or they are in some other way affected by protected ground. And so to the point of undue hardship, the college has to accommodate the disability. For example, if someone needs extra time at an exam because of a disability, that has to be provided. The undue hardship would occur if the health or safety of someone else was put in jeopardy, or if the cost was something that the college could not bear. The duty of accommodation also arises in other contexts. For example, the requirement to have a fair process requires accommodation, and the Accessibility for Ontarians with Disabilities Act requires the college to have accessible facilities, communications, and employment standards.
I understand that the requirements to prevent workplace violence are not strictly speaking a human rights issue. Is that true?
Yes, some workplace violence is based on a ground protected in the Human Rights Code, but the overarching workplace violence provision is found in the Occupational Health and Safety Act. And it's a requirement that colleges have a policy in place and take preventive measures to prevent their workers from suffering violence, and then to respond appropriately to any threats. Now, this requirement technically applies only to workers, but many colleges have extended their policies to council and committee members as well.
Thank you, Richard.